may Allah help all of us and save us from this calamity. All around the world, people are in a very hard situation. Every cloud has a silver lining, as they say. I hope this silver lining is close. Today we have distinguished guests as our speakers. I would like to thank all of the gentlemen before we start. They are really so kind to accept our invitation, even though their agendas are so full of this kind of events. Thank you very much again, the gentlemen. Let me introduce you our panelists. Our first speaker is Deputy Minister of Foreign Affairs of Turkey, Yavuz Selim Kıran. Mr. Kıran, welcome to our online conference again. I hope you can stay with us till the end of the speeches because we have some questions, but I also know that our minister is in New York right now, if I'm not wrong, and you are taking the workload so much. If you can stay, we will be more than glad, but if you cannot stay, we cannot say anything. Thank you very much again. Our second speaker is Communications Vice Director Çağatay Özdemir. Welcome, Mr. Özdemir, again. Our third speaker is Professor Ibrahim Kaya. Professor Kaya, welcome. And the last speaker is Uğur Sevgili. Welcome, Mr. Sevgili. In order to clarify our program, I have to say that this is not a discussion panel. I mean, I will give 12 minutes to all our speakers, one by one. Of course, you can ask some questions by using our live stream chat. I will direct those questions to our panelists, our speakers. Please write the name of the speaker who you want to ask your question to. Let's start with our first speaker, Deputy Minister Yavuz Selim Kıran. Mr. Kıran, welcome again. Your participation is so precious for us to be informed about the Turkish stance with regard to violations of international law in Palestine by Israel. Your topic is Turkey's recent initiatives for the settlement of conflict and the phenomenon of help to Palestinian people in their legitimate cause. It is an important topic, very significant topic in terms of Turkey's struggle to help Palestine and Palestinian people. I wish other states could be brave enough to defend international law for Palestine as much as Turkey. Without further ado, let's give the floor to Mr. Kıran. Please, Mr. Kıran, the floor is yours.
Distinguished participants, dear friends, let me begin by thanking Professor Selman Öğüt for organizing this very important and timely conference. All our attention and efforts are concentrated on the recent developments in the Middle East. We have been appalled by the terrific scenes from Palestine. Our hearts are beating with Palestinian people who once again became the target of Israel. I express heartfelt condolences for Palestinian brothers and sisters who lost their lives because of Israeli aggression. I also wish recovery to the thousands of wounded people. Israel alone is responsible for the tragedy in Palestine. Like any child, a Palestinian child has the right to grow up in their own state, in their own homeland. A Palestinian child has the right to play with his friends, to go to the school, to enjoy life without constant fear of being killed by a foreign army. Like people everywhere, the Palestinian people deserve to live in dignity, prosperity, and security. They deserve to travel and study freely to feel secure. The Palestinian people and international community need an end to occupation right now. That is why the Palestinian people urgently need help in their legitimate cause. And that is why a just settlement to the conflict and an end to the daily atrocities of Israel is necessary and urgent. Dear friends, once again and tragically as usual, Palestinian people became the target of Israel starting from the holy month of Ramadan. More than 200 Palestinians have lost their lives in Gaza, West Bank, and Al-Quds. Half of them are women and children. Schools, hospitals, Red Crescent, and international media were targeted by Israel. Doctors, teachers, children, women, innocent civilians were killed in airstrikes. Israel once again showed its brutal face to the international community. But this recent escalation is not a surprise for those who follow the conflict closely. We have witnessed the same pattern for the last 70 years, unfortunately. Since the Nakba, Palestinians have been gradually deprived of their lands with every occupation and expansion of illegal settlements. Israel provokes Muslims by violating the freedom of worship in Haram al-Sharif, expands illegal settlements in Al-Quds and West Bank, forces Palestinian people out of their houses. The purpose here, of course, is to drive Muslims out of their lands and make an independent state of Palestine impossible. This time, Israel first approved 540 new settlements in southwest Jerusalem during Ramadan. Then started forced evictions of Palestinians from their homes in Sheikh Jarrah. Finally, on 8th of May, violated the freedom of worship in Haram al-Sharif. These illegal actions prepared the ground for the current situation. Turkey and our President Recep Tayyip Erdogan refused to remain silent in the face of this unspeakable aggression. We have taken several diplomatic initiatives. Our President spoke to many leaders around the world and called for an action by international community. Our Foreign Minister Mevlut Çavuşoğlu met and spoke with his counterparts to ensure international support. We must take concrete actions against this brutality. Unfortunately, some members of the international community chose to remain silent against massacre of innocent civilians. They talked about Israel's right of self-defense. Murdering innocent people is not self-defense. It is an open and clear act of aggression, turning into war crimes. As we speak up against these crimes, some dare to accuse Turkey with anti-Semitism. These accusations are totally and, of course, unfounded. Unlike many others, we have no record of anti-Semitism in our history. On several occasions, we extended a helping hand to Jews under threat. Today, we live side by side with our Jewish citizens in Turkey. Our Jewish community have also rejected these unfair accusations. But some countries with a dark history of anti-Semitism have developed a soft spot for Israel and turned a blind eye to its illegal acts. We, on the other hand, have a very clear stance. From the beginning, we have supported the resolution of this long-standing conflict on the basis of international law and legitimacy. We have advocated the two-state solution and called to revitalize the peace process. Sustainable peace and stability is only possible when the illegal and inhumane Israeli occupation ends. That is why we strongly rejected the decisions to open embassies in Jerusalem as they compromise the agreed framework on status of this holy city. Palestinians and Israelis should decide the status of Al-Quds through direct negotiations. As our President Recep Tayyip Erdogan said, the best way for peace in this holy city is to establish a joint commission consisting of representatives of three monotheistic religions. We are also strongly against Israel's continuous blockade of Gaza. Today, Gaza turned into the largest open-air prison in the world. 2 million people living there are in urgent need of humanitarian assistance. Therefore, international community should not only focus on ceasefire, but also mobilize efforts to end Israel's occupation and blockade. UN Security Council once again failed to take a decision to protect innocent lives of Palestine because one of the permanent members, United States, used its veto. The Council is even unable to implement its own resolutions. These resolutions call for Israel to end its occupation in Gaza, West Bank, and East Jerusalem. More than 50 years, Israel ignores this call. This inaction and dysfunction of the Security Council destroy its legal and moral high ground. That is why President Erdogan underscores the need of change in the international system by saying the world is bigger than five. As Security Council cannot fulfill its duties, international community should develop effective means to stop Israel's attack on Palestinians. We mobilized the OIC, which is the most inclusive international organization after the UN. The OIC ministers adopted a resolution by consensus, pointing to the responsibility of the international community for the protection of Palestinian civilians. In the past, inaction of the Security Council led UN General Assembly to adopt landmark resolutions on protection of Palestinians and status of Al-Quds. Today, as we speak, UN General Assembly convenes again to discuss the situation in Palestine. Our President Recep Tayyip Erdogan led the international efforts to hold the General Assembly meeting. Our minister attends the meeting together with several other foreign ministers, including Palestinian Minister Malki. At the General Assembly, main issue to be discussed is the protection of the Palestinian people. UN General Assembly adopted a resolution in 2018, which called for the protection of the Palestinians, ending the blockade of Gaza and providing humanitarian assistance. Now, we should work for the establishment of a necessary mechanism, including sending an international protection force in order to provide safety and security of the Palestinians. Another priority is to make Israel accountable for its aggression and violation of international law. Next week, UN Human Rights Council will meet to discuss the human rights abuses of Israel and review mechanisms to deter its acts of aggression. International Criminal Court has a special role in this respect. International community should support and closely follow Palestine's application to the court in 2015. We support the unity of Palestine and encourage them to achieve reconciliation. Last year, we hosted an important meeting in Istanbul between Fatah and Hamas, which led to the decision to organize elections in Palestine. Unfortunately, these elections were postponed because Israel prevents voting in Jerusalem. Dear friends, a just, comprehensive, and lasting solution in Palestine can no longer be delayed. Turkey will continue to support the legitimate struggle of the Palestinian people. We believe it is a legal and moral responsibility for the international community to protect Palestinians from aggression and to find a lasting and fair solution to the conflict. We will continue to work with the international community to achieve this goal. Thank you for your attention.
Thank you very much, Mr. Minister. Let me just touch upon some of the very important points of Mr. Kran. He said that more than 100 people were killed by Israeli forces. Most of them are civilians, including doctors, babies, children, women. The last 70 years, it is like that. Israelis, unfortunately, has been doing it for the last 70 years, and Israel is provoking Muslims by violating the right of worship and many other fundamental rights and freedoms too. And Turkey refuses this kind of attitude, and our president is always saying violations must be ended, and Turkey is always calling for close cooperation and collaboration. Mr. Kran also underlined this fact, and Mr. Kran also stated that we don't have any kind of anti-Semitism in our history. We support the resolving of the conflict by ending the illegal and illegitimate Israeli occupation. And he also, Mr. Kran also stated that Israel's continuous blockade towards Gaza Strip is also a big problem. It's also another violation of international law. Gaza is the biggest open prison of the world, Mr. Kran stated. And he also touched upon the Security Council's resolutions with regard to the occupation of Israel on the Palestinian territories. That's why our President Erdogan is always reiterating that world is bigger than five. And Mr. Kran finally said that solution cannot be delayed. Thank you very much, Mr. Kran, for your very precious speech. I hope you can stay with us, but if you cannot, as I said, we can't say anything about it because you have a very full agenda. You are so busy. Thank you very much. So let me turn to Mr. Özdemir. Thank you very much again for your participation, Mr. Özdemir. Let me introduce him a little bit. He's the Communications Vice Director and has a PhD in International Relations. He's an expert of the discussion point of the impression management of media. His topic is impression management of the international media outlets. Mr. Özdemir, welcome again. Before you start, let me quote from Malcolm X. He stated that the media have the power to make the innocent guilty and to make the guilty innocent. So they can easily distort the facts, he says. And he also stated that the media is the most powerful entity on earth. when I take a look at some of the TV channels and newspapers, Mr. Özdemir, I see that they are acting like fans rather than being objective. Fans of Israel, of course. They are supporting Israel's violations deliberately, and they are just playing the three monkeys when it comes to the rights, fundamental rights and freedoms of the Palestinian people. Do you agree with me, Mr. Özdemir? Please, the floor is yours.
Thank you so much. I will explain everything about you mentioned it. Dear participants, today I will discuss the aspects of international media outlets and Israel's impression management. I am grateful for the opportunity to speak alongside such distinguished panelists, and I thank the organization committee for facilitating this timely discussion. Almost 3 decades ago, American historian Howard Zinn published a memoir with a memorable title, "You Can't Be Neutral on a Moving Train." That metaphor, though simple, delivers a powerful message. It's a reminder that complicity does not only stem for approval or support. It is also rooted in silence in the face of injustice. The idea of being neutral on a moving train is especially relevant to media, because neutrality is considered essential in that world. Hence the question, at what point does neutrality amount to complicity? That question is not intended to target reporters or organizations, but an honest conversation is the public interest. I will talk about 3 problems today, all of which are related to the question of neutrality. First, journalists openly taking sides and acting like spokespeople for Israel. Secondly, there is the illusion of neutrality in the media. Thirdly, we have the suppression of neutrality. Most people are already familiar with the first problem because it causes uproar. People dislike it because it blurs the line between influencer and journalists. It is one thing for a Gulf-based influencer to say, "Why can't the Palestinian just vacate Al-Aqsa Mosque and simply go home?" It is quite another thing for CNN chief media correspondent to tell his viewers, "What were the Israelis supposed to do?" This is pretty obvious, but only additional point that we have reached a point where some journalists do not mind taking sides openly. The second problem is more complex. It's related to illusion of neutrality. There are at least 2 ways in which of facade of neutrality hides behind in know or unknown bias. The first part of problem is more obvious because it's self-censorship. People are afraid of speak up because Israel and its supporters falsely equated and critic of Israel with anti-Semitism. They are afraid of getting passed over the promotions, losing their job, or losing their scholarship for saying that killing children is not self-defense, and it is certainly not a right. The second part of the illusion of neutrality is harder to detect. You have to read between the lines and really engage the text of story to see it. If you look closely, you will see Palestine is portrayed as a magical place in the media. It is a place media buildings collapse for no apparent reason and children simply drop dead. It is a place with plenty bloodshed but no perpetrator. This false neutrality is also hidden in the distortion of context. We keep hearing that Israel retaliates against the Palestinians, but we are deprived of background. There is no mention of what happened at Al-Aqsa Mosque or in Sheikh Jarrah neighborhood. There is no mention of far-right settlers, Palestinians out of their family at homes. This is a lie by omission, and it is a disgrace. The third and final problem is the suppression of neutrality, which is linked to impunity. Over the weekend, Israel destroyed a civilian building in Gaza, where the officer of Associated Press, Al Jazeera, and others were located. It is violation of Article 19 of the Universal Declaration of Human Rights, which identifies freedom of expression and right to information as fundamental rights. Basic freedom targeted by Israel to cover the truth. Freedom and safety of the media are in fact essential for the protection of all other human rights. That event caused the media to attract more attention than usual. Buildings collapse will definitely leave an imprint. For instance, the reporters became the story. Advocacy groups and journalists were quick to condemn the attack, while some also attempted to justify Israel's move. For the record, this wasn't the first time. In November 2012, Israel bombed another media building in Gaza 2 days in a row. There was no pushback, there was no investigation, there was no accountability. Indeed, Israel counts on the fact that people tend to forget such things. That impunity enables to encourage similar attacks on the media. While trying to cover the developments on the ground, many journalists risk their lives and they often become the target of Israel army. In 2018, 2 journalists were killed and many were injured, even though they were wearing vests or helmets, bearing and word press. Israel's war on the media reminds more popular thought in experiments. As you know, if a tree falls in the forest and no one is around to hear it, doesn't it make a sound? Israel perspective is similar. If you commit a war crime, but there are no journalists to document it, do you really commit a crime? That is the essence of the current intimidation campaign. In the lead up, Israel's destruction of media building in Gaza, the Israeli security forces repeatedly targeted journalists reported from the Alaska Mosque and Sheikh Jarrah neighborhoods. TRT and Anadolu Agency were among those media outlets whose staff were threatened, beaten, and shot with rubber bullets on the ground. Likewise, freelance journalists have been working under terrible circumstances. Is it less criminal to shoot a reporter who works for TRT or Anadolu Agency or Al Jazeera than to hurt a journalist who works for Associated Press or BBC? Is the life and safety of brown journalists worth less than life and well-being of white journalists? As the modified quote goes, first they come from the journalists. We don't know what happened after that. Finally, let me note that Israel continues to deny journalists access to Gaza. This is attempt to suppress information. This is attempt to suppress information. It is about stopping the world from learning about Israel's war crimes. It is also about keeping the Israeli public in the dark, about ruling the empathy, and about building the radicalized base. Following the recent developments, it seems that people around the world raise their voices against Israel, flagrant violation of human rights. For decades, many generations in some Western countries thought that Israel's policies were unquestionable and Palestinians were clearly posing threat to the security of Israel. Yet, now more people started to acknowledge that Palestinians' basic human rights are violated by Israel on a daily basis. They question the unconditional support for the Israel government. In order to enable the international audience to fully understand the root of causes of the ongoing developments, the media need to put a spotlight on atrocities committed by Israel. I believe that responsible and principled journalists alone are in a position to tackle the problems that I have outlined here today. Only they can uphold the principle of journalism and keep the media honest. Once again, thank you for your organization. I am grateful for the opportunity to address you today. Thank you so much, dear my colleague and Mr. Professor Selman Öğüt. Thank you so much for your invitation.
We thanks a lot. Thank you very much for your presentation. some of the important topics again. I took some notes with regard to the speech of Mr. Özdemir. He said that you cannot be neutral in a moving train. He also made a quotation. And what about being neutrality when it comes to complicity? He asked this question. This kind of approach let people uproar. Question is a very simple question. Why can't the Israeli soldiers just leave the Al-Aqsa Mosque? The people are asking this simple question, Mr. Özdemir said. And he also touched upon the result of the distortion of the facts and stated that Israel is retaliating Palestine as a corollary of this distortion. Some of the media outlets are claiming it. They are saying it's a retaliation. Of course, it is not. It is a sheer violation of international law. Associated Press and Al Jazeera buildings have been attacked by Israeli forces, and they attack media to silence the freedom of speech, Mr. Özdemir said. And by doing that, Israel awaits responsibility. So Israel's mentality is something like that, Mr. Özdemir underlined. If you commit a war crime and no journalist can see the war crime, so there is no crime. So because of that, they are trying to hinder the journalists to enter into some of the places, and they are killing the journalists, especially deliberately some of the journalists on purpose. We can call it with the legal terminology melis afotot. And they are thinking that by silencing the media, by killing the journalists, by attacking the media buildings, they can cover the truth. But it's not like that. They cannot evade the responsibility by that, because everything is under the observation of the international community. We know everything, all of the the violations of rights by Israeli forces. Thank you very much, Mr. Özdemir. Now we turn to Ibrahim Kaya. Professor Kaya, welcome again. Your topic is so important in terms of the breaches of international humanitarian law by Israel, of course. Let me introduce Professor Kaya. He's an expert of international law, of course, completed his master's degree at University of Nottingham, and he completed his PhD degree at University of Kiel. We are really glad to see him in our conference today. Professor Kaya, as we all know that Israel is so reckless when it comes to the rules of international law, especially the humanitarian law is always violated by Israel every single day. Please enlighten us in terms of international law. The floor is yours.
Thank you very much, Mr. Chair. Dear honorable participants, ladies and gentlemen, it's an honor for me to be part of this panel and to address you on international humanitarian law issues of the Israeli-Palestinian conflict. International law of armed conflict regulates how the states must behave to protect individuals, of course, as much as possible in armed conflicts, including the internal ones, whether the conflict has started lawfully or unlawfully, whether the state claims that it acts in self-defense or not. It doesn't matter. In any case, these rules, international humanitarian rules, should be honored and observed by all parties. International humanitarian law has wider content in the sense that it aims at protecting civilians and people not involving in armed conflicts during any time, whether there is an actual armed conflict or not. As long as the clashes are there, these rules should be observed. Although the emergence of rules regulating the conduct of parties during an armed conflict can be traced back to the even ancient times, the emergence of such rules in modern sense, independent from conscience or religion, is quite a new phenomenon. These rules have started to evolve in the 1860s among European countries, including the Ottoman Empire. The first such convention was the Convention on Amelioration of the Condition of Wounded on the Field of Battle, which is also known as the Red Cross Convention, signed in 1864 in Geneva. Most important such conventions concluded in the 20th century are 4 Geneva Conventions of 1949. They concern respectively protection of sick and wounded in land wars, protection of sick and wounded in naval warfare, protection of prisoners of war, and the protection of civilians, which is directly relevant to today's circumstances. These 4 Geneva Conventions have been developed further by 2 additional protocols in 1977. There have been many more important developments, most important of which have been the emergence of new conventions and trials of war criminals through international and ad hoc tribunals. The latest development is the establishment of the ICC, International Criminal Court, as a permanent international criminal court. Generally speaking, the rules of armed conflict are divided into 2 groups. First group is rules applied before the war and called jus ad bellum. These regulate the legality of initiating an armed conflict. And the second group is the rules applied during an armed conflict and called jus in bello. Again, let me underline, it doesn't matter whether the war or the conflict started legally or illegally, whether the state in question acts in self-defense or not. In any case, jus in bello rules or international humanitarian law rules have to be observed all the time. According to the relevant rules, states are not completely free to choose any weapon or method to defeat their enemies in a military conflict. They have to strike a balance between military necessities and the necessities of humanity. Firstly, weapons causing unnecessary pain and death are prohibited. Secondly, weapons targeting places and persons outside the conflict are prohibited. Thirdly, when using weapons, the principle of proportionality should be observed. Moreover, with special regulations, certain kinds of weapons are prohibited, like weapons with burning effect, gas and chemical weapons. As to the methods, those which demolish the trust in certain figures like medical units or civilians are prohibited. Secondly, it's prohibited to demolish the properties without a military necessity. And finally, methods which damage to the environment are also prohibited. When we look at the list of protected persons, we could see the injured and sick, prisoners of war, and maybe most importantly for today's circumstances, the civilians. Civilians are those who are not involved directly in the military conflicts. They have to be treated humanly. They cannot be targeted, killed, injured, tortured, and enslaved. Their moral or religious values have to be respected. They cannot be discriminated against on race, nationality, religion, or similar considerations. Of course, there is an academic discussion whether the conflict between Palestinian Authority and the Israeli government is an international one or not, but it doesn't matter. Under Article 3 of 4 Geneva Conventions, which is the common article, the article is applicable in case of armed conflict, not of international character occurring in the territory of one of the contracting parties to the 1949 conventions, and surely Israel is a party to these conventions. Article 3 also applies to a situation where the conflict is within the state, between the government and the rebel forces, or between the rebel forces themselves. As I mentioned, these 4 Geneva Conventions were added by 2 protocols. Protocol 2, which is supplementary to this article, has expanded this provision, but some of the states, including Israel, is not party yet to this protocol. Article 3 offers an international minimum protection in case of non-international armed conflict to persons taking no active part in hostilities, mainly the civilians in this case, including members of armed forces in certain situations specifically stated in the article. Human and non-discriminatory treatment are 2 important protections offered under this article. It prohibits certain acts as against protected persons which are enumerated in this article. Common Article 3 assumes greater importance than Protocol 2 to the Geneva Conventions for the reasons that the Geneva Conventions have been ratified by a large number of states, and also Article 3 has been claimed to be declaratory of customary international law on this point, meaning that every state is bound by the minimum requirements provided by Article 3. The problem with this article is that it's applicable only to a situation which is an armed conflict, all right? However, the term armed conflict has not been defined in the convention. In the absence of the definition of armed conflict, it is left to the state to determine whether an armed conflict exists or not. In times of disagreement, of course, with regard to the applicability of the Common Article 3, the only applicable criteria is the intensity of violence. When you see the warplanes playing over territories, you could easily declare that this is surely an armed conflict. It doesn't matter whether the state in question call it armed conflict or not. When you see there's a huge loss of life, today, I guess the total number of the death toll in the recent conflict is around 400. Surely you could assume that it's an armed conflict. In the conduct of hostilities, civilians may never be a target. A civilian can be targeted if they are a direct participant in hostilities. If not, children, women, elderly cannot be targeted. There are 2 levels to the current conflict, and therefore 2 levels within which breaches occur. Within military engagement via the conduct of hostilities, and outside of military engagement via besiegement, blockage. Let's turn to the second point. Let's turn to the blockage of Gaza, which has been touched by the previous speakers. Hague regulations, Geneva Conventions, their additional protocols, customary international humanitarian law, and the military manuals of various countries all outlaw collective punishment in armed conflict. A collective punishment is a punishment inflicted by a party to a conflict on prisoners of war or people who are outside the fight, the civilians living in Gaza, for example, for an act committed by an individual or the enemy party to the conflict. Is the siege of Gaza a collective punishment? The short answer is yes, because several UN Secretary Generals, UNHCR, ICRC, and plenty of other important and honorable persons and entities have all labeled the siege of Gaza as a collective punishment. The ICRC, referred to by scholars as the guardian of international humanitarian law, pointed to the restrictions on the Israeli buffer zone, which has restricted access to the farmland, the 3-mile restriction on fishing off the coast of Gaza, and the power shortages that have crippled the Gazan health system as instances of this collective punishment. It breaches customary and treaty-based rules of international law regarding collective punishment and indiscriminate attacks, breaching the fundamental international humanitarian law principles of distinction and proportionality. Thank you very much.
Thanks a lot, Professor Kaya. It was a very precious speech, and I have to touch upon some of the important points from your speech as a moderator of this conference. I like to do it, and audience, I also say that it's very good when this speech has been ended. Professor Kaya stated that the Geneva Conventions, 4 Geneva Conventions, are protecting some of the buildings, some of the people, like wounded people, the civilians, and emergence of the ad hoc tribunals, and then ICC. This phenomenon is also based on the Geneva Conventions. And then 2 groups of laws of conflict, the armed conflict, whether they are international or internal armed conflicts, has been touched upon. Rules applied before war, jus ad bellum, and rules applied during war, jus in bello. Both of them are violated by Israeli forces, Professor Kaya stated. For example, a state cannot choose a weapon which is against the international law, which is against the laws of war. Some weapons are prohibited, like chemical weapons, and some of the targets cannot be determined by the armies of the states, but Israel is also doing it. The previous speakers also touched upon the buildings like Al Jazeera buildings or United Nations schools. We also unfortunately experienced this kind of attacks by Israeli military forces. Prisoners of war and their rights must be also protected, but we cannot see it, unfortunately, in this conflict. Israel is violating international law, Professor Kaya stated, on the basis of Geneva Conventions. Whether you are, Professor Kaya underlined this fact, whether you are a high contracting party of those conventions or not, customary international law is also binding for you, because the jus cogens that we say always as the international law experts, jus cogens cannot be violated, the peremptory norms of international law. And Geneva Conventions, the common articles of the Geneva Conventions, and also the additional protocols are also envisaging some of the responsibilities for the states. Whether you are a high contracting party of the conventions or not, you have to, you are bound with those conventions. And when we come to the Gaza Strip, Professor Kaya also said, Hague and Geneva Conventions and the other regulations of international law, all of them, they prohibit the collective punishment. It is also against international law, but Israel and the other so-called great powers which are supporting, unfortunately, Israel, they are punishing collectively. The collective punishment is against international law again, but the people who try to live in Gaza, unfortunately I have to say like that, who try to live in Gaza, they are under very hard conditions, and they are unfortunately under the collective punishment. Thank you very much, Professor Kaya. Now we will listen Mr. Sevgili. He is a lawyer in Istanbul and an ex-staff of International Criminal Court. I think, Mr. Sevgili, you are the only Turkish citizen who worked there for more than 6 years at International Criminal Court as an international bureaucrat, and your experience is really so precious. I appreciate your personal effort to make a precious career like this. He will give a speech on the liability of Israeli authorities before ICC, which means the breaches of international law on Palestinian territories requires both the responsibility of Israel as a state and the responsibility of Israeli authorities. Here the responsibility is the criminal responsibility, of course. Therefore, please correct me, Mr. Sevgili, if I'm wrong, starting from the Prime Minister Netanyahu to commanders of Israeli army, all of the people, all the men in charge can be adjudicated before ICC. Is it possible to try Israeli authorities before ICC? Mr. Sevgili, the floor is yours. Thank you very much.
Thank you, Salman, for your nice words. Good afternoon to everybody. I would like to thank you for this invitation again and greet the distinguished panel members and dear friends. At the outset, please allow me to commemorate yesterday, that is the May 19th, dedicated to youth of Republic of Turkey by Atatürk. And I would like to note that since the establishment of Republic of Turkey, Turkey didn't affected by the ongoing armed conflicts surrounded by its neighboring states, including Middle East. One of the main reasons is that this republic is established with strong and deep foundations, and that's why I would like to commemorate Atatürk as well with this opportunity. And before I go into details of the ICC and its investigation, I would like to highlight that the power of balance in Palestinian and Israel conflicts is not balanced, obviously. For instance, the Gaza Strip, as we all know, is a highly populated area, I think 2 million. And any military intervention to Gaza may cause serious potential mass crimes under international humanitarian law. In so doing, as we all know, as of March 2021, which is a couple of months ago, the Office of the Prosecutor of the ICC has officially decided to open an investigation with respect to the situation in Palestine. The investigation, therefore, will cover crimes within the jurisdiction of the court that are allegedly being committed as of 13 June 2014. And of course, what it still continues, including the current armed conflict as of today. And the prosecutor of the ICC, she has determined that there are reasonable bases to commence an investigation to the situation of Palestine. I would like to highlight that is the issue, because the mentality of the criminal court is almost similar to any modern national court. The prosecutor has to have reasonable basis to open an investigation, similar to Turkish criminal courts. So she really believed that there are reasonable basis to commence an investigation, and based on this, she opened an investigation. So therefore, as of March 2021, actually, both Israelis and the Palestinians are under investigation of the International Criminal Court. So, as we all know, on how the investigation has started, I would like to also highlight that historical development, chronological development of that. the 16 January 2015, and the prosecutor opened a preliminary examination of the situation of Palestine based on the Palestinian authorities' acceptance under the Rome Statute, Article 12, Paragraph 3. And later on, as we all know, the Palestinian Authority has also, in 2018, referred the situation to the Office of the Prosecutor under Article 13 and 14. So shortly after all these issues, after 5 years, the prosecutor has decided to determine a ruling of the territorial jurisdiction, of the existence of a territorial jurisdiction of Palestine, because as you know that Palestine is questioned whether it's a statehood or not under international public law. So the Office of the Prosecutor did not ask whether the Palestine is a state or not, but the question was whether the court has a territorial jurisdiction with regards to the referral of the state of Palestine, it's herself. And right after that, in 2029, end of 2019, the beginning of 2020, the chamber decided by majority that the court has the jurisdiction, territorial jurisdiction, vis-a-vis the situation in Palestine. So in its decision, the chamber stated that the territorial jurisdiction includes the Gaza, West Bank, and East Jerusalem, the occupied lands. And in addition to that, the chamber also stressed that the court solely determines the scope of the court's territorial jurisdiction for the purpose of Rome Statute as requested of the prosecutor of the ICC. The decision states that it is not up to the court to decide or make analysis whether the Palestine is a state or not under public international law. So the chamber only replied the request of the OTP vis-a-vis the territorial jurisdiction. So once the OTP understood that they have the territorial jurisdiction by the decision of this court, they continued the investigation, and apparently a couple of months ago, as I stated, they finalized the preliminary examination, and based on the findings of the preliminary examination, they decided to open an investigation against those in both sides, the perpetrators of war crimes. They added that there are some war crimes has been committed in both sides, potentially, of course. And what are these crimes? It is said that the prosecutor has found that there are reasonable basis to believe that war crimes have been or being committed in West Bank, East Jerusalem, and Gaza Strip. Potential cases arising from the situation would be also admissible still, and there were no substantial reasons to believe that an investigation would not serve the interest of the justice. So based on these three findings, the court initiated the investigation. The prosecutor has found that there are reasonable basis to believe that members of the Israeli Defense Forces committed war crimes in the context of 2014 hostilities in Gaza.
Mr. Sergey, sorry, could you please a little bit closer to the microphone?
Yes, okay.
Please.
So the prosecutor, apologies, the prosecutor has found that there are reasonable basis to believe that the members of the Israeli Defense Forces committed war crimes in the context of the armed conflict in 2014 in Gaza. This is one of the findings. I would like to also open a parenthesis in that, because since weeks there is armed conflict going on in Israel and Palestine. So obviously the court's investigation also includes these attacks, these crimes, potential crimes. So this is just the latest finding dated 2014 as part of the referral of the Palestine. In addition to that, the court believes that intentionally launching the war crime that the court believes, potential war crime, is that there are intentionally launching disproportionate attacks in relation to at least 3 incidents in Gaza in 2014. Willful killing and willful causing serious injury to body or health, a war crime potentially committed by the Israeli Defense Forces. Intentionally directing an attack against objects or persons using distinctive emblems of Geneva Convention. So based on these two findings in principle, the court has reasonable basis to believe that the potential war crimes has been committed in 2014 Gaza. Moreover, the prosecutor has found that there are also reasonable basis to believe that members of the Israeli authorities committed war crimes in the context of the war in 2014. Sorry, not the war, in the context of hostilities, armed conflict in West Bank, including East Jerusalem. Here, the crime that is listed in the findings of the Office of the Prosecutor, the transfer of the Israeli civilians into the West Bank since 13 June 2014, which is also still continuing. I think Sheikh Jarrah is also the latest events what has been going there since weeks. Also, including this, they are all potential war crimes. In addition to that, the prosecutor last to find out that there are also reasonable basis to believe that the member of the Hamas and the Palestinian armed groups potentially committed war crimes in the context of the 2014 hostilities. War crimes, what war crimes the reasonable that they believe potentially are the intentionally directing attacks against civilians and civilian objects, using protected persons as shields, willfully depriving protected persons of the rights of fair and regular trial, willful killing, torture, or inhuman treatment, and or outrages upon your personal dignity. Of course, the crimes that are listed by the OTB are not limited, and these are also not officially approved. There is no, the investigation still continues. These are the prosecutor is just suspicious that there are these war crimes committed by the suspects on both sides. So here the question arises: the principles of distinction and disproportionality is two important things when we analyze these war crimes. If a random targeting is done by Hamas, okay, and those random targets kill civilians, these are, whether we like it or not, these are potential war crimes. Or as long as these attacks are, of course, analyzed substantiated by evidence, investigators of the court on the ground. On the other hand, if the Israeli forces, IDF, the Israeli Defense Forces, attack specifically targeted civilian objects, or as Mr. Chatra is stated, attacks the media places such as Al Jazeera, all these are obviously potential war crimes. But of course, how does the prosecutor functions? They need to be in the field, collect evidence. What are these evidences? Of course, the reports, videos, journalists' findings, and video reports, and all these evidence that one can imagine, written documents, witness statements, also victims' statements. All these evidence is collected by in principle, should be collected during this investigation phase from both sides. And based on this collection, the prosecutor probably will re-establish and again will list the crimes against the perpetrators in both sides. So as for now, whatever we say, this party has committed war crimes, or the other party has committed war crimes, in both cases they are all under the eyes of the international criminal court. They are potential war crimes. The evidences are not collected yet, but there are still reasonable basis, strong belief that these war crimes are potentially committed. So what should be, how should we should also check the random targeting and specific targeting issues, and we should also apply how the prosecutor applies the principle of the proportionality, because if an attack is disproportionate, like killing someone attacks you with stone and you shoot him with a pistol, that is disproportionate. Disproportionality. I mean, I just want to simplify the issue, the case. So in such cases, the court will take all these issues into consideration. And for instance, acts of Hamas in the conflict, as I told you, in the current conflict, such as shooting rockets without targeting, are potential crime under international humanitarian law. I mean, these are not, of course, my personal opinion, but these are how the court analyzes it objectively. Of course, shooting of the Gaza by the Israeli Defense Forces without targeting is also a potential crime under IHL. So in order to make a better assessment, all the facts on the ground, as I said earlier, needs to be taken into consideration, such as collateral damage, was very important. For instance, shooting a military objective and incidental loss of life may not be a war crime unless otherwise it is proportionate. And regarding the regarding the current conflict, today's conflict, the Office of the Prosecutor of the International Criminal Court has already warned all parties to the conflict for the latest events. I don't know if you follow her Twitter account, official account. She stated that the latest conflict could be considered as part of the investigations of the OPP. So that is to say, all the crimes, potential crimes that are committed on the field by Israel are taken into consideration by the Office of the Prosecutor. And I would like to also highlight the admissibility issue. There is an issue of principle of complementarity. This is a very important thing most people don't know, so I would like to pay attention to that, the audience as well. There is a principle of complementarity under Article 17 of the Rome Statute, is one of the requirements. The court considers this as the last resort of decision-making system. The court, in principle, leaves the national court, the party to the conflict, to take a decision and to start the investigation, prosecute, and if possible, render judgments. But of course, in so doing, the court, under this principle, monitor the legal proceedings, and the court really looks for whether these legal proceedings are undertaken genuinely and legitimately and fair trial principles. So as long as any nation, this could be Israel or Hamas court, Palestinian court, I'm sorry, if this court proves that they fairly tried the perpetrators of these crimes in their national court, International Criminal Court only stops, not stops, continue her investigation, but they just monitor the situation and check whether these legal proceedings in both parties are genuinely undertaken and are carried out based on fair trial principles and legitimately done. If so, then the court leaves it. If not, in the meantime, while these legal proceedings still continues at national level, the court also doesn't stop. They also continue to do further investigation on the ground, and the court also continues, if possible, then indict the authorities, and then the chambers decide whether the crimes are committed or not. And so the idea here is presumably the court give the chance to states in line with the principle of this complementarity. So this is actually a chance for both states. However, that doesn't mean that, as I said, that the investigation is finalized. The investigation of the ICC still continues, and the court in the meantime monitor the situation in line with the principle of complementarity. Regarding the individual criminal responsibility, we all know that the court does not accuse any state. The court looks for the perpetrators, for those who are ultimately responsible for commission of these crimes under the jurisdiction of the jurisdiction of the court. The goal is here for the person who is ultimately responsible to commit the crime under the jurisdiction of the court, and that person shall be tried before the ICC. The court does not look for the guy who shot the civilian who committed the war crime, not the lowest level. The court looks for the ultimate responsible one. But of course, it has to be legally linked the orders, if there are written orders, witness statements, video records, because states active. So all these orders, in some cases they are orders written, or in some cases there are witnesses, there are video reports, journalists reports. All these evidences collected on the ground, and based on this hierarchy, the court seeks for the ultimate responsible of the person who committed the crimes. And
can we wrap up, Mr. Sevgili? We have some questions for you too.
Please.
Okay, thank you very much.
I'm done.
Thank you very much. The investigation has started. Mr. Sevgili stated that on the basis of Article 13 and 14 on territorial jurisdiction. So the ICC prosecutor didn't question the Palestinian situation, whether Palestine is a state or not. So territorial jurisdiction means that there's a territory and the territory is occupied by an armed forces. So it's a good sign for the Palestinian people who have been ignored by the international community for the decades. But the ICC stated that the territorial jurisdiction is so over here. So the war crimes, both sides potentially also undermined by you. But of course, the war crimes and also the violations of international law by Israeli forces are really so clear. And prosecutor also said, according to Mr. Sevgili, there are findings that Israel violated international law, especially during the attacks in 2014, willful killings and intentional attacks against people with distinctive signs like uniforms, and also the principles of some of the principles like distinction and principle of proportionality are violated. So here, thank you very much for this very precious. Yeah, please. As a
one more thing I would like to highlight, because I mean I worked there for many years and I know how the people start of the court functions that most people don't know, and unfortunately everywhere in the world they have a political approach.
We cannot hear you. Please.
Unfortunately, most people have a political approach when it comes to existence of the court, but I worked there for many years and I know how the people that are ethical and how they really work hard. I know about in person as well. I always know this. The court is always acting independently, and I would like to highlight this because I also see that it is not a political statement; it's a true statement of the court authorities. They always act independently, impartially, without any agenda, and they bind only themselves with the legal text of the court, mainly of course the Rome Statute. They don't do anything apart from this. But unfortunately, because the Hamas issue is a political situation, it is difficult for many people. Everybody expects justice to be done quickly, but under this condition that within international reality.
Yes. Thank you. Thank you very much for your additional information. So we have two questions for Professor Kaya from the audience. What can be done against Israel due to their violations of international law under the roof of United Nations? So United Nations is the biggest international organization in terms of the Security Council resolutions and United Nations General Assembly's resolutions too, and different organs of United Nations are really so active and so powerful with regard to the international conflicts and the problems. What do you think about, Mr. Kaya? What about the solutions that we can develop maybe under the roof of United Nations? And the second question is responsibility of the international organizations. Of course, the international organizations are also responsible because of the ongoing violations. Since those organizations like United Nations cannot hinder, cannot stop the violations. Could you please wrap up those two questions and give an answer to us?
Thank you very much, Professor Selman Öğüt. These questions are really relevant and very important questions. The first question relates to the United Nations, and we all know that United Nations is the biggest international organization consisting of nearly 200 states, and actually it was intended to unite the nations, but unfortunately we could see the fact that due to the organizational structure of the United Nations, the power of the United Nations is not somewhere where we would like to see. And of course, there's a reform agenda for the United Nations, and the United Nations has always been criticized of being the voice of only most powerful nations, mainly the permanent members of the Security Council. And again, the Israeli-Palestinian question or the conflict is an evidence of the fact that the UN really needs a reform, and it has to have a more reflective nature. Different types of states, different groups of states should be represented in the Security Council of the United Nations. When we look at the current structure of the Security Council, it may be said that it only reflects the realities of 1945 or 1950s, but today we really live in a different kind of world, and the representation issue, the democratic representation of the states in the United Nations Security Council unfortunately doesn't exist. And this is one of the reasons that many states has lost their faith in the United Nations. Sometimes it's used as a scapegoat. If you do not want to do anything, you just put the blame on the United Nations. But we really need to underline that the current structure of the UN doesn't let it address the current conflicts and also current problems of the world. I mean, this is my personal opinion. I'm not expecting much from the United Nations, unfortunately, but every time this type of questions arise, the need for the reformation of the United Nations also comes to the agenda of the world. And the second question relates to the responsibility of other international organizations, as mentioned by the speech of the Deputy Foreign Minister of Turkey. OIC is the second largest international organization. Although many states, many members of the OIC underline the importance of the current conflict, and they propose really great suggestions, resolutions, and all of the resolutions are passed anonymously. There's a consensus on what to do, but apart from the members, apart from the presence of their members, international organizations, again, such as OIC, are powerless when they meet under the roof of OIC. They say yes, they vote for the adoption of a resolution, but when it comes to the implementation of this resolution, many states, even the members of the OIC, are extremely reluctant. I mean, for their internal political agendas, many members of the OIC, they try to show that they play a great role, but they only raise your hands, nothing else. I mean, the concurrent suggestions have to be made, and more importantly, these resolutions have to be implemented, of course, by the participations of the members of these international organizations. Otherwise, as I said, they are not strong organizations. It doesn't matter how many members they have. Thank you very much.
We thank you, Professor Kaya. Those were very important points for us. Of course, the international organizations shouldn't await the responsibility. When we take a look at the draft articles of United Nations International Law Commission in 2011, the international organizations are also under the responsibility of the wrongful acts. If an international organization cannot fulfill the obligations which are stated in their treaties, in their regulations, so those responsibilities can also be the issues of the international violations by the international organizations. What I try to say is, if United Nations Charter is always indicating the protecting the preserving and protecting the international peace and security, and if United Nations as an international organization, as Professor Kaya stated, that the biggest international organization cannot protect the international peace and security, of course, according to draft articles of the United Nations International Law Commission, which is issued in 2011, those wrongful acts also requires the responsibility of United Nations. One question, for actually two questions, but I just collect two of them, and want to offer Mr. Sevgili about the ICC. Of course, one of our listeners asked this question: can we say that ICC tries to give responsibility equally? And do you think ICC is willing to find the real responsibles like US? What I understand is, I think some of the audience, they think that ICC is trying to show that there are two equal powers. Of course, there are not two equal powers. And they also ask that the responsibility should be shared. Should it be shared equally, or should we say that there is a real responsible or more than one responsible state, some other states too? Maybe some, maybe we have to talk about the concept of complicity. What do you think about it, Mr. Sevgili?
Regarding, I go from the last question regarding USA. I mean, it's unfortunately not relevant when it comes to the ICC, because first of all, the US is not a state party. More than that, there is no territorial jurisdiction. Even if US was a state party to the ICC, the crimes committed, the situation is in Palestine, and the parties there are the parties who commit the crimes during the armed conflict, and As far as I know, US and all other countries, they are not there in the hostilities. Of course, ICC will take, first of all, this is very important. ICC is a legal institution, it's not a political institution. Of course, it's a sensitive establishment, and it's a big achievement under these conditions because ICC is bound by the international institution, and international law is not function as, of course, the Professor Ibrahim Kaya also knows, does not function as a national law. There are power games going on, real political issues, international dynamics. But apart from this, ICC really managed to establish itself in a very objective and impartial way because it is bound, the institution bound itself with legal text. And the legal text is the Rome Statute and other rules of procedure, evidence, and element of crimes and others, plus, of course, the jurisprudence of other international institutions, courts. So whatever the ICC makes decision or request, all these issues are done under this legal text. So, of course, based on the fact that it's a kind of rule of law within the institutions. As long as this rule of law are applied by the court, there will be always, the decisions always will be taken objectively. And ICC is not, that's why ICC makes investigation in this conflict for both sides, because it is the prosecutor's responsibility to collect evidence within the jurisdiction of the court, and regardless of who committed the crimes. And regarding this criminal responsibility, it functions like a national court, criminal court system. It's all about collection of evidence. So if the evidence are there objectively, and if there are strong beliefs that person A, let's say Netanyahu or someone on the other side, commit these mass crimes under the jurisdiction of the court. If this evidence is linked, and then of course they all will be indicted, and then the legal procedures continues until the final findings, decision, judgment will come after appeal chamber. So this is it is not a different institution than any other modern criminal legal system, but it has its own legal text, and the court binds itself with this legal text of the court. So all these questions, people, of course, they don't know because, first of all, they are not lawyers. Secondly, they think politically, which is understandable. But this institution is a political institution. Yes, it is an international organization, but it binds itself with the principles of the legal text of the court, impartially and objectively.
Thank you very much. Of course, Mr. Sevgili is talking on the basis of the Rome Statute and ICC, the procedures with regard to ICC, International Criminal Court. This is a very specific branch of international law. We have to say that, and it's very young, and it is still on the way of development. It improves its procedures too. We experience some new decisions with regard to procedural rules of International Criminal Court, for example, for the Myanmar case. And maybe ICC will widen the responsibility, the criminal responsibility with regard to international criminal law. Maybe it will widen the duties of the court. We don't know it, but we shouldn't understand that Mr. Sevgili is saying that Israel and Palestine are equal powers and they are, under the international law regulations, they are in a conflict in an equal way. It's not something like that. Since he's an criminal law expert, he is given information about the international criminal law, criminal courts, international criminal courts statute, Rome Statute, and all of the procedures that can be worked out by using the procedural rules of International Criminal Court. Thank you very much for your contribution. So thank you for your patience and thank you for your attention. We have lots of questions, but we have to stop here because our participants also have, actually they are run out of time. They are really so kind to accept our invitation. For the last words, I have to touch upon the sheer fact that Israel is bigger than Israel, because Israel is backed up by some of the so-called great powers. But we have to say that Palestine is also bigger than Palestine, because Palestine is also backed up by some of the international actors, states, whatever you say, because the people, the states supporting Palestine, they are trying to preserve and protect the international peace and security. But those who are trying to support and backing up Israel, they have to know that when you violate the international peace and security, the domino effect will also deteriorate your situation too. It will harm, it will give harm, it will damage your international relations too. And we have to know that United Nations Security Council, General Assembly, the resolutions of those organs of United Nations, they have been always underlining that the international peace and security must be preserved. According to international regulations, according to United Nations Charter, the international peace and security must be preserved. If you spoil the peace and security, we have to say that the effect will be so detrimental. We have to accept that what goes around comes around. You reap what you sow. So we have to be so cautious with regard to international peace and security. Palestinian people are killed by Israeli forces. So if international community will, some of the members, let's say some of the members of international community continue to play three monkeys, so the deaths of civilians will be normalized by some of the international actors, which is really so gut-wrenching, which is really not acceptable. Thank you very much for your attention, and our participants, our speakers are really so kind to accept our invitation. Have a nice day. I hope this international issue, the massive killings of the civilians, the overt violations of international rules by Israel, I hope for the close future we don't see something like that, but as I said, not just some of the states, all of the states must put their heads on the table and have a conclusion with regard to this very important and very sorrowful problem of the international community. Thank you very much again, and have a nice day.